What should you do if your I-485 is denied, but the problem that caused the denial is something you can fix? That sounds like it should be simple. If the medical exam was missing, get the medical exam. If a document was not submitted, submit the document. If the affidavit of support was incomplete, correct the affidavit of support. If a translation was missing, get the translation. If USCIS misunderstood something, explain it. But in adjustment of status cases, the answer is not always that simple. A denied I-485 is not just a paperwork setback. It can affect work authorization. It can affect advanced parole. It can create unlawful presence or status concerns depending on the person's facts. And in some cases, it can trigger the government to issue a notice to appear, placing the person in removal proceedings. So today I want to talk about a specific category of cases. The I-485 was denied, but the underlying problem may be fixable. The question is, do you file a motion? Do you refile the I-485? Do you do both? Or do you prepare for immigration court? This is general information, not legal advice for any particular person. These cases depend heavily on the denial notice, the person's immigration history, their manner of entry, whether they are an arriving alien, whether they are still eligible for adjustment, and whether DHS has already issued or filed an NTA. The first lesson here is that the I-485 really needs to be filed correctly the very first time. Adjustment of status is not just a form, it's actually an evidentiary package. The filing might require proof of lawful admission or parole, a qualifying immigrant petition, proof that a visa is available, the I-864 affidavit of support if that's needed, civil documents, identity documents, any prior immigration records, criminal records if you have any, translations, medical exam documentation, and evidence addressing every single ground of inadmissibility that could apply. Too often folks think of USCIS as a process where missing pieces can always be fixed later. Sometimes that's true. USCIS might issue a request for evidence. They may spot what's missing and give the applicant a chance to respond. But that really shouldn't be the main filing strategy. The safer approach is to assume that your first filing could be your only clean shot to present the case before a denial. We're seeing more cases now where USCIS moves from a request for evidence, or RFE, straight to a denial without any further notice of intent to deny. In some situations, people expect another warning before the case is denied. That expectation, though, can be pretty risky. USCIS might decide that the applicant had a chance to provide the evidence, didn't do it, and now the record is ready for a decision. That's why a correct, complete, documentarily supported response to any RFE is just so important. A missing document might seem small at first, but after a denial, that missing document could be the reason someone is no longer in a pending adjustment posture. When an I-485 gets denied, the first question really isn't, can we fix this? The first question is, why exactly was it denied? There are different kinds of fixable problems. One category is a missing document problem. Maybe the I-693 medical exam was missing. Maybe the birth certificate wasn't in the right format. Maybe a translation was missing. Or maybe USCIS asked for a tax document or some financial evidence that just wasn't provided. Another category is a correctable legal or factual misunderstanding. Maybe USCIS overlooked evidence already in the file. Maybe USCIS misread the response. Maybe the applicant actually submitted the document, but USCIS did not properly connect it to the case. Maybe the officer treated the person as ineligible based on a mistaken factual assumption. A third category is a problem that is fixable only through new facts. For example, a new sponsor may now be available. A medical inadmissibility issue may now be resolved. A waiver may now be available. A priority date may have become current. A previously missing relationship or eligibility document may now exist. Those are all very different situations. A case denied because USCIS made an error is not the same as a case denied because the applicant failed to submit required evidence. And a case that can be fixed by filing a new document is not the same as a case that requires a waiver, a new petition, or a change in eligibility. So, the denial notice has to be read carefully. The strategy comes from the reason for denial. In a denied but fixable I-485 case, there are usually three main paths to consider. The first path is a motion to reopen or reconsider, usually on Form I-290B. The second path is refiling a new I-485. The third path is preparing for removal proceedings if the government issues a notice to appear. Sometimes one path is clearly better. Sometimes two paths may be pursued together. Sometimes cost, timing, and removal risk make the decision very difficult. The mistake is assuming there is always a single automatic answer. After an I-485 denial, one possible option is a Form I-290B motion to reopen or reconsider. But this is where many applicants misunderstand the process. A motion to reopen is not simply a chance to say, "We have the missing document now." It is not always a second bite at the apple, and it is not always the best way to fix a case that was denied because required evidence was missing. A motion is strongest when there are new facts, a government mistake, a record error, or an objectively changed circumstance that affects the denial. For example, a motion may make sense if USCIS denied the case for failure to respond to an RFE, but the response was actually submitted on time, and USCIS failed to connect it to the file. A motion may also make sense if USCIS sent the RFE or notice to the wrong address, ignored a properly filed change of address, or denied for abandonment even though the applicant did not receive a proper opportunity to respond. The same is true if USCIS overlooked evidence that was already in the record, misread a document, applied the wrong legal standard, or made a clear factual error. A motion may make sense if another government record changed after the denial. For example, CBP corrected an I-94, a court vacated a conviction, or USCIS reopened and approved the underlying I-130 or I-140 petition that supported the I-485. That also applies if the denial was based on an admissibility problem that has now been resolved through a waiver approval, a corrected medical finding, or another post-denial legal development. There may also be rare cases where a document truly could not be obtained earlier despite serious efforts. But that is a hard argument. The applicant has to show more than, "I did not have it yet." USCIS may ask, "Why was it not submitted when it was required?" The stronger case is one where there is proof that the document was objectively unavailable, that the applicant tried to obtain it, and that the document became available only later. But the important thing to remember is that a motion will be evaluated on USCIS' own objective standards of availability. Applicants often think evidence is new because they personally did not have it before. USCIS may see the same evidence as late, not new. If the birth certificate, tax transcript, medical exam translation, or affidavit of support could have been obtained and submitted before the denial, USCIS may not view a motion as the right cure. That is why missing document denials are dangerous. If the I-485 was denied because the applicant failed to submit something required, a motion may be possible, but it may also be vulnerable. USCIS may simply say the applicant had the burden to file a complete case and did not do so. In that situation, refiling a new complete I-485 may sometimes be the cleaner path, especially if the person remains eligible and no NTA has been filed with immigration court. But if the denial was caused by USCIS error, a defective notice, a corrected government record, or a genuine post-denial change in the legal or factual posture, a motion may be worth serious consideration. Due to the limitations on I-290B motions, refiling may be the better option when the problem is cleanly curable and the applicant remains eligible for adjustment. For example, if the I-485 was denied because a required medical exam was missing, and the applicant can now file a complete package with the medical included. Refiling may be the most direct affirmative path. The same may be true where a financial document, civil document, or required form was missing, and the corrected package can now be submitted properly. The advantage of refiling is that it creates a new pending I-485, assuming USCIS accepts the filing. That can be very important. It shows that the applicant did not simply let the denial sit, it shows that the problem was addressed. It creates a new receipt, a new record, and a new procedural posture. But refiling is not risk-free. The filing fee may be significant. The medical exam may cost money. Work authorization and advanced parole may need to be addressed separately depending on current rules and filing strategy. And most importantly, refiling does not guarantee that USCIS or DHS will refrain from issuing an NTA based on the original denial. Now, this is the part many clients do not expect. A person may think my I-485 was denied, but we fixed it and refiled, so everything should be fine. But not necessarily. The government may still issue a notice to appear based on the original denial. The NTA may already be in process. The new I-485 may not be recognized before the NTA is issued. Or the government may recognize the new filing and still decide to pursue removal proceedings. That is why refiling must be explained honestly. It may be the best available step, but it is not a shield we control. The attorney does not control whether DHS issues an NTA. The attorney does not control when DHS files the NTA with immigration court. The attorney does not control whether USCIS continues adjudicating the refiled I-485 after proceedings begin. The new I-485 can improve the record. It can create arguments. It can support requests for discretion. It may help prevent or resolve court proceedings, but it cannot guarantee that court will be avoided. Should a notice to appear be issued, then the person is in removal proceedings, and the case must be addressed with the immigration court. The exact charge in the NTA is important. Sometimes the government may allege that the person remained in the United States longer than authorized. Sometimes the government may allege that the person failed to maintain the terms of a non-immigrant status. Sometimes the government may charge inadmissibility grounds, especially in arriving alien cases. Those theories are not identical. A pending I-485 may create a period of authorized stay for certain purposes, but it does not necessarily restore lawful non-immigrant status. So if the government says the person has no authorized stay, the new I-485 may be directly relevant. But if the government says the person failed to maintain the terms of their original status, the argument may be different. This is why the defense strategy cannot be generic. You have to read the NTA, identify the charge, compare the charge to the actual timeline, and decide whether the pending or refiled I-485 defeats the charge, weakens the charge, or mainly supports discretionary relief. Another major issue is whether the person is considered an arriving alien. In many non-arriving alien cases, once the person is in removal proceedings, the immigration judge may have jurisdiction over adjustment of status. But arriving aliens are treated differently. In many arriving alien cases, USCIS may retain jurisdiction over the I-485, and the immigration judge may not have authority to adjudicate adjustment except in a narrow exception. This matters because the strategy may change. If USCIS has jurisdiction, the argument may be that immigration court should be dismissed, terminated, administratively closed, or continued, while USCIS adjudicates the I-485. If the immigration judge has jurisdiction, the judge may say, "We are not waiting for USCIS. If you want adjustment, pursue it here." That distinction can affect the entire case. If an NTA has been filed with the immigration court, one possible response is to contact OPLA, the DHS attorneys, and ask them to dismiss or join a motion to terminate. The argument is that the case does not need to be in removal proceedings. The denial was based on a fixable issue. The issue was promptly fixed. A new I-485 was filed. The government's resources and the court's resources would be better used by allowing the corrected application to proceed. This is worth trying, especially where the problem was minor and the applicant is otherwise clearly eligible. But it is not guaranteed. DHS may agree, oppose, or simply decline to exercise discretion. If they refuse, you may still be able to make a unilateral motion to terminate. A motion to terminate may argue that DHS cannot sustain the charge, that the NTA was improvidently issued, or that the facts alleged in the NTA do not match the actual procedural posture. For example, if the NTA claims the person lacks any authorized stay, but before the NTA was filed, the person had already filed a new I-485 that created a new authorized stay posture, that may support a termination argument. But again, this depends on the charge. If the charge is failure to maintain non-immigrant status, the pending I-485 may not defeat the charges directly. So termination can be powerful, but it needs to be tied to the actual allegations and legal basis in the NTA. If the judge is not willing to terminate, another option may be administrative closure. Administrative closure means the court removes the case from the active calendar temporarily. It does not grant status. It does not approve the green card. It does not end the case forever. It pauses the court case while something outside the court may resolve the issue. In this context, the argument is that USCIS should be allowed to adjudicate the corrected I-485 because approval may resolve the need for removal proceedings. This may be strongest where USCIS clearly has jurisdiction over the pending I-485. It may be weaker where the immigration judge believes the court should adjudicate adjustment directly. Administrative closure should not be presented as an indefinite delay. It should be presented as a practical, limited request. The problem that caused the denial has been fixed. The corrected I-485 is pending, and USCIS adjudication may materially resolve the court case. If the judge will not administratively close the case, a continuance may be the fallback. A continuance keeps the case active but delays the next hearing or deadline. The argument is similar. There is a pending corrected I-485, and the outcome may affect or resolve the removal case. Some judges may prefer a continuance over administrative closure because the case remains on the docket, but a continuance offers less protection. The court may eventually stop waiting and require the case to move forward. If the immigration judge decides to keep the case and exercise jurisdiction over adjustment of status, the applicant may need to pursue the I-485 before the immigration judge. That is a much bigger shift than many people realize. This is not simply a matter of sending the same green card application to a different address. It is not just refiling paperwork. It means the adjustment case may have to be presented in immigration court as a form of relief from removal. That can involve a very different process from USCIS. With USCIS, the case is usually submitted as a paper application, followed by biometrics, document review, possible RFEs, and in many cases an interview. With immigration court, the case becomes part of removal proceedings. The applicant is not just asking an agency officer to approve a benefit. The applicant is asking an immigration judge to grant relief while DHS is prosecuting the removal case. That means the case may require pleadings, written filings, exhibit preparation, legal briefing, witness lists, testimony, and a merits hearing. The applicant may need to testify under oath. The spouse, petitioner, joint sponsor, family members, or other witnesses may need to appear in court. DHS may cross-examine the applicant and witnesses. The immigration judge may ask questions directly. The judge may want to see not only that the forms are complete, but that the applicant is legally eligible, admissible, credible, and deserving of adjustment as a matter of discretion. So when we say the I-485 may need to be renewed or refiled before the judge, that phrase can understate what is really involved. The issue is not only whether another filing fee is required. The issue is that the entire case may need to be prepared for courtroom presentation. This can create several additional burdens. First, there may be a filing fee issue. The client may already have paid to refile the I-485 with USCIS. But if the case moves into immigration court, the court may require a separate court-based I-485 filing and fee. EOIR currently lists the immigration court I-485 filing fee at $2,980. Second, there may be a preparation cost issue. Court-based adjustment generally requires more attorney time than a simple USCIS refiling. The attorney may need to review the NTA, address removability, prepare court filings, organize exhibits under EOIR rules, prepare witness lists, draft or update declarations, prepare the client for testimony, prepare witnesses, attend hearings, and respond to DHS objections. Third, there may be an appearance issue. The client must attend immigration court hearings. If witnesses are needed, they may also have to appear. Fourth, there may be a litigation risk issue. USCIS review and immigration court adjudication are not the same experience. In court, DHS may challenge eligibility, admissibility, credibility, or discretion. A case that looked like a straightforward corrected filing may become more contested once it is placed before a judge. There may still be arguments that the court should treat the case as a renewal of an already filed application rather than as a brand new filing. There may be arguments against unnecessary duplicate fees. There may be a fee waiver option if the client qualifies financially. But no attorney should promise that the court will accept the prior USCIS filing or prior USCIS payment as enough. The client also needs to understand that even if the court accepts the case procedurally, approval is not automatic. The applicant must still prove eligibility for adjustment. That means proving the qualifying basis, visa availability if required, admissibility, proper documentation, and favorable discretion. So when considering a denied but fixable I-485, the possible immigration court path has to be discussed from the beginning. The warning is not just that there may be another fee, though that is significant, more than double the ordinary I-485 filing cost. The fuller warning is this: if DHS places the case in immigration court and the judge decides to adjudicate adjustment there, the case may become more expensive, more formal, more time-consuming, and more contested than a USCIS refiling. So, the question of what to do in the case of an I-485 denial has no universal answer. If USCIS made an error, a motion may be the best first step. If the case was denied because a required document was truly missing, refiling may be more practical. If timing is urgent and NTA risk is high, some cases may require considering both: a motion to preserve the argument that the denial should be reopened, and a new filing to create a corrected pending application. But doing both increases cost, and it still may not prevent an NTA. The decision should be made after reviewing the denial notice, the person's status, eligibility, admissibility issues, timing, current visa availability, and the likelihood that USCIS will treat the defect as curable through a motion. To evaluate how to proceed in your own case, consider this framework. First, identify the reason for denial. Was it missing evidence, legal error, factual error, inadmissibility, abandonment, failure to respond, or lack of eligibility? Second, determine whether the problem is actually fixable. Some problems are easy to fix. Some require a waiver. Some require a new petition. Some are not fixable at all. Third, determine whether the applicant remains eligible to adjust. Fourth, evaluate the motion option. Is there a strong argument that USCIS should reopen or reconsider? Fifth, evaluate the refiling option. Can a new complete I-485 be filed quickly and properly? Sixth, evaluate NTA risk. Is the person out of status? Was the I-485 their only pending protection? Is there a basis for DHS to initiate proceedings? Seventh, prepare the court contingency before the NTA arrives. That means knowing whether to seek DHS dismissal, termination, administrative closure, continuance, or court-based adjustment. The mistake is treating denial as a single problem. It is really several problems at once: benefit eligibility, timing, enforcement risk, court jurisdiction, and cost. So, what should you do if your I-485 is denied, but you can fix the problem? The answer is, act quickly, but do not act blindly. Read the denial carefully. Identify the exact defect. Decide whether a motion, a new filing, or both make sense. Understand that refiling may not prevent an NTA. Understand that if the case moves to immigration court, the strategy may change completely. And understand that a court-based I-485 may involve a separate immigration court filing fee, currently listed at $2,980. The bigger lesson is that the best defense is a complete I-485 filing from the beginning. A missing document can become a denial. A denial can become an NTA. An NTA can become an immigration court case. And an immigration court case can create jurisdictional problems, additional legal fees, and a possible second I-485 filing fee. If the problem is fixable, there may still be a path forward. But the path has to be chosen carefully, and the client needs to understand both the opportunity and the risk. A fixable denial is not the end of the case, but it is also not a harmless mistake.